time.
Let's see if this. Can you do me a favor? Can you just and test.
Testing. Can you hear me? Do I sound good? Did you get my email? Sweet. Here are your things. Clear my stuff off.
If they wave it to me, they can. Mouse is also real. As long as you like, it's a wireless mouse.
You use a wireless?
No,
Oh, no. I don't have a clicker. Chances are I definitely don't have a wireless. I would make like a snapper.
Yeah, I would go through break. Sometimes it kind of get hot. It's oh, okay. It's just there will be a studio Ghibli next month. Well, studio say that what is that? Yeah, I missed that. Yeah. Yes, what should I say?
Well, since I completely interrupted the conversation, you could talk about what was the worst team of the season?
The worst team of the season? The worst team was, I don't know. The Mystics were great. They just disappointed in the finals. It was really sad. Okay.
Yeah. I sent the link to Messenger for the live stream.
To Facebook Messenger?
Yeah. You can share it over there.
Okay. Yeah. Yeah. I went to the last. But I would have paid that to see.
If I sit here, does that block the? Okay. What about this?
I saw the ones in the restaurant.
Is this blocked?
This is like, it's yours. I'm more to the right.
I just want to get rid of these.
The guy from the library from you.
Oh, okay.
I wasn't sure if that was a request or not.
I think that's just a courtesy. I don't, but I'll ask when I.
I've been paying. I like to go see friends here. Usually on fixed screen. And see what they say.
Oh, I'm okay. How about you?
And then I got an email and for some reason said, someone came for further than I did. Someone came for further than I did.
Okay. My so I was supposed to pick up his It's one of those things where I could have just stayed in there. Yeah, you're gonna own. Yeah, yeah. He's in London and he's cool. He's like, he's not young, he's done. I mean, it's reasonable. Like, they he's like alpha, so they're not. So they were there. Yeah.
Hello, if you can all take your seats, we'll kick things off. Yeah, clap once if you hear, wait, what is it? Clap once. If you hear me, clap twice. Yeah, that. I'll know for next time.
All right. This is not a functional mic. It's just for the people who are tuning in online. So you won't hear me any louder. Thank you so much for coming out to this little workshop that we have planned. I'm Miriam Zeringhalam. I am part of the leadership of an organization called 500 Women Scientists. We started after the 2016 election as a way to promote women in science and leadership and change the face of what a scientist looks like by building leaders in our communities. And I'm really excited that we've, through this journey of 500 Women Scientists, been able to partner with a bunch of different really amazing organizations like the Union of Concerned Scientists. And we have Mike Halprin from, yes, I wanted to make sure that I got your last name right. Who, do you want to say a few words about what Union of Concerned Scientists does?
Sure, and I'm the one who should be excited about being with you guys because 500 Women Scientists has done such awesome organizing and work over the past 18 months, and Climate Science Legal Defense Fund over the past 5 years, is it now? About something like that. UCS has been around for about 50 years working on science and policy issues. We have a science protection project which gives confidential legal advice and confidential ways of sharing information publicly for federal employees who think they are seeing something that isn't quite right. So people can check that out if they are interested, and do a lot of work on protecting scientists from political interference in their work and surveying scientists in federal agencies to measure the level of political pressures that they face, and a lot of advocacy to sort of create that space so that scientists can continue to do their work and so that science can continue to inform environmental and public health policy. So thank you all for being here and learning more about how you can fully engage in this conversation.
Cool. And so without further ado, let's bring up the experts, Lauren Kurtz and Augusta Wilson from Climate Science Legal Defense Fund. Really thrilled to have your expertise here.
Thanks, Miriam. And thanks 500 Women Scientists and UCS for organizing this. We did a similar event in New York, which seemed to go pretty well. But, if you guys have questions, feel free to ask as we're going along, just in case there's something that's not clear. We'll also have time at the end for Q&A. So my name is Lauren Kurtz. I'm the director of CSLDF, Climate Science Legal Defense Fund. I'll just say a little bit about what we do. We were actually formed back in 2011, pre-current political era, as a PayPal page by a meteorology professor who was crowdfunding for the defense of scientists who found themselves under fire by people who were politically motivated to target their work. So what's the best way to move the slides forward? Just, okay. I'm not a good winker, but I'll try. So we actually were started to help scientists respond to things like open records requests. And I'll just start off by saying, you know, first, open records laws are great, wonderful things. Many pro-science groups, including, for example, a Union of Concerned Scientists, have used them to great effect to better understand how government is spending taxpayer money and provide government accountability for certain issues. The wrinkle is when it comes to publicly funded individual scientists, the laws have not always gotten up to speed with how science actually works, especially at the state level. If you're, for example, a state public university professor, these open records laws in some states allow people to do things like request all your peer review correspondence, your ongoing research, your in-progress data, your unfunded grant proposals, your in-progress grant proposals. It can be quite an invasive tool that can really be harmful, and it can allow hostile groups to really target individual researchers in really invasive ways. So when we were founded actually in 2011, it was because and I'll talk about this more in a minute, it was being used in Virginia against a University of Virginia public university professor. Basically, a pretty aggressive anti-science group was trying to obtain every single email he'd ever written or received. It was about 38,000 emails. And they were openly stating that he was fraudulent, that he was misrepresenting data, really bogus, ridiculous claims, accusing him of all sorts of malfeasance. And you can imagine if you give someone 38,000 emails and they're looking for something bad, like there's probably a sentence or two in there you didn't write so well, or that someone sent you and that could have been written better. So it was a pretty egregious fishing expedition through his materials, and we were founded to help him fight back against that. So this is a report that we put out about a year ago, and it just looks at how different states use open records laws. If you guys are public university professors, I highly recommend you check it out. Also true if you get any sort of state funding. If you are in a C, D, or F state, I am sorry to tell you that it is relatively easy for people to get your materials. It's not something that every researcher has to face, but it is something to be aware of. And we'll talk a little bit more later about how people who are subject to state open records laws should try to protect themselves. It's also true, as I'm sure some of you know in here, that if you're a federal agency employee, the federal FOIA laws can be used against you too, although in general, the protections for science are a little better. There have been, especially in the past few years, some very helpful court cases that have protected scientific research at the federal level. And if you're a federal grantee, you know, you're fairly protected, much more so than for an agency employee, which is a very bizarre division, that a federal grantee is more protected than a federal agency employee, but that's just how it works. You're getting the same federal money, but for some reason, the way that the laws have been divided up, they've recognized some really, I think, helpful protections at the grantee level that have not been recognized at the employee level. And again, we'll talk about that a little more later. So this is just a summary of the federal laws. The case that I was referring to a second ago, there was a case that came down about 2 years ago now and actually finished through 2017. So it was actually started by the Obama administration, continued by the Trump administration. And it said that federal agency scientists should be protected in the same way that high-level policymakers should be protected. And the protections that were implemented decades ago to protect the deliberative process of policymakers and the ability of policymakers to bat around ideas and explore candid opinions and be able to throw out, you know, kind of maybe wacky solutions that may or may not be implemented. The sorts of protections that we give policymakers to fully explore their thoughts should be awarded to federal scientists. So that was really helpful. It's interesting to me that the Trump administration continued it, but they did, possibly because they have their own objections to open records laws. The Shelby amendments is what I was referring to, that refers to scientific grantees under federal agencies. So usually what happens is if you get a federal grant, someone can request certain information of the awarding agency, and that is different from being an agency employee or a public university professor, something like that, in two ways. One, you don't have to deal with it. A lot of these laws, they will fall directly on you, and there's a lot of work, sometimes a lot of legwork to respond to these requests. So if you're a federal grantee, at least you don't have to be the one who's actually putting together the response. Two, it is limited to quote unquote research data. So for example, if you get an NSF grant, you're already required to share your final data with NSF at the completion of your grant. And people can request that under open records laws. But they can't request things like your drafts, your peer review correspondence, your preliminary research, your emails to colleagues, et cetera. All the things that we at CSLDF should be protected for the reasons I said a minute ago about, you know, allowing scientists to do things like bat around ideas and exchange candid communications and write, you know, correspondence to their colleagues late at night in ways that can possibly be taken into context by hostile groups. Those sorts of things are protected under the regulations surrounding federal grantees. State open records laws, as I said a minute ago, unfortunately, that's a whole mess, and many states just haven't really gotten up to speed. Some of these laws date back to like the 1890s, written way before anyone could ever conceive of email, written way before really the government got into funding science, and they just haven't been up to date. Some states are really good, some states are not. If you have questions about your individual state, please check out our website or come talk to us, and we'll be happy to walk you through some of the more specifics. So I started off by saying that we were created as a PayPal page. We were created as a PayPal page to crowdfund for the defense of Dr. Michael Mann. He is sort of the poster child for a lot of this. Some of you may have heard of him. He was one of 3 scientists who wrote this quote unquote hockey stick graph, which was published in the late 90s, and it pulled together about 1,000 years of temperature records. And he found himself targeted by all sorts of groups that disputed his research conclusions, basically, which said that the last 50 or so years of warming was really anomalously high and out of context for what had previously been happening. So he got targeted in all sorts of ways. I'm not going to go into all of them because it would take up our entire time, but you know, he got targeted by Congress, he got targeted by the state attorney general, he got targeted by rude people online, et cetera, et cetera. And the reason that we were founded is because he had spent 6 years at the University of Virginia, which at the time didn't really have an open records policy, and Virginia itself had a very confusingly written open records law. And so this group, as I mentioned before, tried to get 38,000 of his emails through open records laws, and the University of Virginia at first was going to hand them all over. And Michael Mann said, you can't do that. You can't be handing over 38,000 of my emails to a group that openly has called me a fraud. No one will want to be on a peer review committee with me. No one will want to collaborate with me. No one will want to fund me. It's going to make it really impossible for me to continue my work. So that's where we came in. The University of Virginia came back to the table, thanks, I think, in large part to not only the threat of him actually intervening in the lawsuit, but groups like UCS and AAAS and these other scientific societies speaking out and saying, you really can't leave him out to dry like this. And the case went all the way to the Virginia Supreme Court in 2014, and the Virginia Supreme Court agreed with Michael Mann and the University of Virginia and said, we can't be forcing Virginia Public University professors to turn over all of their correspondence, because no one would ever want to be a Virginia Public University professor. No one would ever want to work with a Virginia Public University professor. No one would ever want to fund a Virginia Public University professor. So that was really great. Of course, it took a lot of money and a lot of time and heartburn to get there, but still, you know, I think it's a really positive outcome. But there are 49 other states, and as I mentioned before, not every state has really sorted out this issue. We actually have been involved in a case in Arizona, which is really similar to this one and has not gone as well, involving the exact same plaintiffs seeking the exact same sorts of emails. And in Arizona, they just don't have the laws the way they did in Virginia. I mean, they do, but the judge has interpreted them in a really funky way. So it's a whole thing. Long story short, state open records laws are definitely something you need to be aware of if you get public money. Federal open records laws, the FOIA applies to, but to a lesser extent. So I'm going to turn it over to Augusta now, who will talk a little bit more about some other scientists who have been affected.
Thanks. Hi, everybody. So as got mentioned earlier, my name's Augusta. I'm a staff attorney at CSLDF, and yeah, we're gonna just tag team it a little bit here. Yeah, so this is just to pick up with another example of a scientist who really went through the ringer with open records laws and some other kind of interesting situations. So I will just tell you her story a little bit because it's helpful to kind of illustrate the types of things that scientists have been impacted by, that CSLDF has sort of generally speaking been formed to get involved and help provide them support when they're encountering these situations. So this is Dr. Debra Swackhammer. And her story goes back to the 90s. That's really where to start. She, at the time, was on the faculty at the University of Wisconsin, and she's a toxicologist. She's an environmental chemist. And she was studying a pollutant called toxaphene that was being found in the Great Lakes at the time in a sort of at a surprising level. It's fairly toxic, and it's associated with the paper industry. So she was doing research into toxaphene and what's happening with that. She also, incidentally, and it's actually kind of relevant just to illustrate what happened to her. At the time, she was married to someone who worked at EPA. And he was positioned at EPA's regional office in Wisconsin, and they had fully disclosed their relationship, and it had been vetted, et cetera, but somebody clearly did not wish this research to go forward and sort of seemed to see that relationship as a weak link. So Dr. Swackhammer was targeted with what is, I believe, still to date, the largest open records requests in the state's history. Picture a room like this just filled with boxes of files. She was obliged to spend a huge amount of time going through old records, and the request was really extensive, wanted 15 years worth of records, wanted unfunded grant proposals, pre-publication materials, raw data, extremely invasive. Her husband also sort of got drawn into this situation because this all managed to trigger sort of an internal situation at EPA whereby he was recalled to EPA's DC office. They had to live separately for quite some time. So this was really quite an ordeal. And it's just, we just tell it as an example of the way in which these laws sometimes, unfortunately, really are weaponized against scientists when people don't appreciate the research they are doing. So fast forward to 2017, and it's amazing because the story changes but continues. So Dr. Swackhammer went on to have a pretty illustrious career, and in 2017, she was the chair of the Board of Scientific Counselors at EPA, which is a board that provides EPA with advice about basic science matters, what research is good, what research is not, what research should you pursue and consider, and what should you not. And EPA has a lot of sort of boards like this, scientific advisory boards. There are multiple. They have some different functions. And in 2017, she was the chair of BOSC, and she was, in the course of her duties through her multi-year term, set to give testimony before Congress. And in that testimony, which she submitted, finalized, and had vetted, as was sort of the normal course of things, she was planning to talk about the fact that she was very concerned that the current administration was essentially hollowing out these scientific advisory boards. Positions not being filled, boards not meeting. She was expressing deep concern about that. And after her testimony was submitted, she started receiving emails, phone calls from the chief of staff at EPA, Ryan Johnson, who was telling her, you have to change your testimony. She sort of has gone on the record since then as saying she felt incredibly bullied and it was a very stressful situation. She declined to change her testimony and she went ahead and she gave that testimony before Congress. The result of which was that she was in fairly short order dismissed as chair of the committee. In the middle of her term, which is highly unusual. So just sort of, you know, a story about, we haven't worked with her specifically, but it's sort of a story that's been, you know, circulating in the media about, you know, ways in which scientists have been affected in particular by current policy. And, you know, it also sort of brings in this open records laws. So it's a good illustration. And we can move on to the next slide. Thanks. Do you want to talk about Linda Birnbaum?
I will maybe use this as a point to say some of the examples like Debra Swackhammer and also Linda Birnbaum are people we have not worked with, but they're helpful because they're already in the news, and a lot of the people we work with, we try to keep out of the news, so you have not heard about their perils, and we like to keep it that way. But we have dealt with people who had a very similar issue to this, and it's unfortunately a thing that I think is especially salient these days as scientists get more interested in activism and advocacy. So Linda Birnbaum is the director of the National Institute of Environmental Health Sciences. She is a trained researcher. She wrote an editorial in Science magazine. And the long and short of it was that she did a review of various pesticide regulations and concluded that some of these pesticides, when they were approved in the 70s and 80s, we knew less about them than we know today. And perhaps that the regulations were not as stringent as they should be because we've since learned that many of these pesticides are a lot more harmful than we had originally realized. So she writes this piece in Science magazine, and she was actually a co-author, but I believe her other co-author is not a federal employee, which is where the sticking point arises. She had a sentence in there towards the end saying that, you know, part of this shows the importance of having citizens engage with their government to have better regulations, was really the summation. And she got herself in hot water with Lamar Smith and another congressperson who accused them of violating anti-lobbying laws and using her perch as director of the National Institute of Environmental Health Sciences to, quote unquote, create a grassroots lobbying campaign, which is a federal employee she's not allowed to do. We'll talk a little bit more about anti-lobbying regulations later because many of you here, I assume, are in some way affiliated with the federal government, and it is helpful, I think, to realize that anti-lobbying laws do apply, more so to federal grantees than federal employees, another funky distinction that may not always make sense, but is there. And as a federal employee, she is not allowed to do things like foment grassroots activism. And she found herself by Lamar Smith and this other congressperson. Nothing ever came of it. It really went by the wayside, but it certainly was, I'm sure, an unpleasant experience. And is something that happens on a semi-regular basis. You know, a federally funded scientist gets involved in something public-facing and, you know, attracts the ire of some legislator who would prefer scientists not get involved in such things. So we will talk a little bit more about how, especially to keep yourselves safe in that space. So that brings us to what is lobbying. Lobbying is attempting to influence a politician or public official to do something specific, usually voting on a specific bill, voting, for example, on a Senate confirmation, conducting a particular activity, usually in a way that benefits your particular organization. So for example, if, you know, a classic instance might be you work for a health insurance company and you have lots of meetings with Congress people about the health care bill. Lobbying is legal. In fact, federal agency employees have a lot of leeway in what they can do, but certain things are prohibited, and that's where the Anti-Lobbying Act comes in. So the Anti-Lobbying Act seeks to prevent federal money from being used to influence legislators in certain ways. There are many ways in which it is totally considered appropriate, especially for federal employees. Grantees is where it gets funkier. Don't do anything, if you get federal grants, don't use federal grants to talk to your congressperson is basically what it boils down to. In a certain light, this makes a lot of sense. People don't want federal grantees to be using their federal grant money to ask for more grant money. Really, my understanding is that this all comes from the contractor side of things. Contractors and grantees get lumped together, and so you can understand how federal contractors shouldn't be using their federal contract money to try and get more federal contracts, but grantees get treated much the same way. So, if you're in the neighborhood of your congressperson on a federally grant-funded trip, you have to be very careful to do things like segregate what you're doing as part of your role as a federal grantee and why you're there with your federal grant money versus doing things on your personal time. So for things like, if you're deciding to stay an extra day in DC, for example, for a conference, maybe that extra day should come from your personal money and not your federal grant. That's just one example. I will turn it over to Augusta to talk a little bit more about the divisions.
I think we're ready for the next slide too. Yeah, so this kind of brings in something that is referred to most commonly as the Byrd Amendment. And without getting us too deep into the legal weeds, this was an amendment to the broad federal anti-lobbying law that was championed by Robert Byrd. The kind of legend, I believe, goes that Robert Byrd was being lobbied by someone who, as Lauren was mentioning, was employed by federal contractors. It was kind of initially tied in, according to lore, to federal contractors. This contractor employed a lobbyist and paid that lobbyist with federal money that Byrd himself had brought home. And the lobbyist showed up in Byrd's office lobbying for more money, and he was incensed. And so we had the Byrd Amendment. And so it does, as Lauren has kind of referenced, interestingly impose some restrictions on grantees and contractors that wouldn't necessarily apply to sort of ordinary federal employees, an employee of EPA or NOAA, for example. It restricts recipients of federal grants and contracts from using those federal funds to attempt to influence a member of Congress in certain ways, and in particular to attempt to influence that member to provide you a new or better or improved or extended grant, loan, or contract. Or also cooperative agreements. I don't know if anybody has bumped into those, but that's another sort of type of relationship that also is covered by this law. So I'll just very quickly note, we're mostly here talking about federal laws. The federal anti-lobbying law and the Byrd Amendment is federal law, but you should be aware that other regulations do extend in some circumstances these principles to dealing with state legislators. So just note that if you are finding yourself inclined to go talk to your state legislator, these types of precautions are also worth considering. So what we feel like we often come and talk to people about all the things they cannot do. And we scare people into feeling like they should not talk at all or do anything. And so we want to make sure that that's not the message that we are conveying, because in fact, that's really not the case. So what I want to sort of focus on here in this slide is being clear about what is it that a scientist who's the recipient of a federal grant or contract or an employee of a federal agency can do if he or she wants to become more involved in advocacy, personal activism, or, sort of even in a professional context, interact with a legislator. So it is absolutely allowed to give a technical or factual presentation to a member of Congress in response to that member requesting that presentation. And this is something that happens. Legislators are working on a bill that involves some scientific concept of any kind, and they feel they want to be better educated about whatever that particular issue or concept is before they draft the bill or before they vote on the bill. And so they do sometimes come to scientists and say, will you come give us a presentation so that we can understand this better? That is fine. You also can conduct nonpartisan analysis, studies, research reports, and provide them to members of Congress. If it's a nonpartisan issue, that's okay. And similarly with sort of broad social economic problems, that's also okay. Again, if it's not something that's really specifically on one side or the other of a particular bill or political issue, you're generally going to be fine. And again, this is sort of what I was saying before. If a legislator is asking for technical advice, that's fine. Next slide. Thanks. So yeah, so this is a lot of information, and wanted to just sort of take a step back and sum up generally, what does all this mean? What can you generally do? So you can meet with a legislator to discuss general policy issues or present nonpartisan analysis. And you can also engage in other kinds of personal activism. So if in your own time you wish to attend a demonstration on some issue, write an op-ed on an issue, or sign a petition, that is okay. We'll go, I think in the coming slides, we could sort of reiterate the advice Lauren's already given, that it's fine to do that. It's going to be really helpful to you to be clear about doing that in your own private time and with your own resources. And finally, so it's actually generally going to be fine to meet with the legislator and in fact engage in activities that probably really are lobbying. Go and say, hey, I want more funding. As long as you are doing that on your own time and you are not using any federal funds or resources to do it. Next slide. So this is what I was kind of referring to before, and let me know if you want to jump in. But this is our sort of most conservative advice. This is what we see as the best way to engage in personal activism and sort of get involved in the political scene if you want to, while minimizing the possibility of any negative repercussions in your professional life. And as we have sort of already said, but we'll say it again, the best way to do that is to take care to separate your personal and your professional activities. So one of the main things to think about is your records, and in particular your emails. The best practice is to do your best to conduct your professional correspondence on your work email account and your personal correspondence, private correspondence, on a private account, and to not mix the two. If you do that, you will help yourself avoid, for example, having your private correspondence pulled into an open records request. So it's really helpful to do that. To make sure that if you do want to participate in personal activism of some kind, you want to circulate a petition or organize a protest, it's going to be the best practice to do that off the clock, not at the office, not on your office computer, not using your office phone, and to do that at home on your own time. And same with sort of other work resources, printers, things like that. Generally, it's probably a good idea if you are taking on some kind of advocacy role to not sort of publicize your work affiliation as you're doing that. Again, this is going to just help you separate your professional life and your personal life and make it clear that you are engaging in this activism as a private citizen. So, you know, perhaps don't go to the protest wearing the logo of your organization, or, you know, put a Facebook post saying, you know, this NASA scientist thinks, consider, if you are going to sign an open letter or a petition, for example, including some kind of disclaimer. To make it clear that, again, that you're doing this as a private citizen. So some just example suggested language, to the extent that your title and your professional affiliation are on a document like that, consider making sure it says that that's for identification purposes only. Language to the effect that these are my personal views and not those of my organization. These will be helpful to you in avoiding any of the kinds of complications that we've described other scientists have bumped into. I think Lauren will have a good example of that coming up. And so also just good practice to make sure that you inform yourself about any policies your organization has with regard to employees engaging in political speech or engaging with the media. Again, just making sure that you know what those policies are will be helpful to you to minimize the likelihood that you're going to run into any trouble. So this is a sort of quick hypothetical example that we actually kind of borrowed from the NIH, as you see on the bottom there. They have some really helpful materials, and this just sort of illustrates one of the examples that we've actually already touched on. Suppose that you are a scientist who's the recipient of a federal grant, and you're planning to travel to DC for a professional conference, and you or meeting at the NIH, as this example actually specifically says, but it could be that, it could be there are many different professional conferences that, as you guys all know, scientists travel for, something like that. And while you are in DC, you want to meet with your senator to discuss next year's budget for your organization. Can you do that? Can you meet with your senator? And so the answer is you can do that, as long as that meeting with the senator doesn't overlap with the actual meeting or conference or whatever else it was you were billing your grant for to come. So if you conduct that meeting with the senator before your other meeting begins or after it ends, that's fine. And as long as your meeting with the senator doesn't cause additional expense to the federal government. So as Lauren was mentioning, if you're going to stay another night in order to have that meeting with the senator, make sure you book that night using your own personal funds and not your grant funds. And not to miss any part of the scheduled activities that you were actually there using the federal dollars for. Yeah, and here's Lauren has a good example here of sort of another way to make sure to stay out of trouble.
Augusta knows this is one of my favorites. So I have seen, I'm sure you all have, a lot of open letters being circulated these days, and definitely do things like put disclaimers. This is a petition that was circulated way back in the beginning of the Trump administration, when Jeff Sessions was only a nomination, and a number of law school professors opposed his nomination for various reasons. And they did put a disclaimer, which was great. Not putting a slide on this, we helped some scientists a few years ago who had put together an open letter and did not put disclaimers, and they got in. It was a very unpleasant situation because they got accused of doing things on behalf of their universities when they didn't intend to be conveying that, and they got ensnared in anti-lobbying accusations. They got accused of misusing their federal funds to do this open letter. It was a whole mess, which the disclaimer very nicely helps avoid. So that was a good thing. These are law professors, so that's good that they knew to put something like that. One thing they didn't think through, though, is they were, many of them at public universities, and they were chatting about this by their public university emails. And then, despite being law professors, were totally shocked when they got open records requests for all of their emails related to this petition. So, a number of them had, I want to say 150 of them got open records requests. Of the several thousand that wrote this letter, about 150 of them got open records requests. Some of them, their universities declined to turn over the emails. Some of them, the universities did. The emails themselves, I don't think actually had anything that interesting, but they could have. We helped a professor a few years ago who was using his work email for a number of things. And basically, when he got an open records request, it ended up turning up a whole bunch of stuff about his vacation because the keywords involved things about his vacation. Nothing embarrassing, but it was definitely not what he was eager to turn over. And you could see a situation where, you know, there's all sorts of materials, especially if it's a person who, you know, an organization that is hostile to you or your work, you may not really be eager to turn over your personal materials to them. So yeah, I think this is a really interesting example because, you know, in some ways they did things really well, and in some ways they didn't do things so well. And there was a lot of emails back and forth about how to write the letter and how much they didn't like Jeff Sessions, et cetera. So that all got turned over in open records requests. This is another example I quite like. You guys may remember about this time last year, right? There was a woman, Julie Briskman, thank you. She was bicycle riding on a Sunday afternoon and passed President Trump's motorcade. And this picture was snapped and it was covered in the Washington Post. And she eventually was fired over it. It's an interesting story for a couple of reasons. One, you know, she worked for a federal contractor. The federal contractor is not the federal government. And so your First Amendment rights don't apply to federal contractors because they are private companies and they employ you at will. Two, she did some, I think, extra bold things in regard to this. Not only obviously was this picture snapped, but she did things like make this her Facebook picture, make this her Facebook cover picture, go to her employer on Monday morning and say, hey, did you see that picture in the Washington Post? That was me. So it made it really hard for her employer, who may have wanted to have more distance between them and this picture. It made them harder for them to do that. And so she was fired. She had a lawsuit against her employer alleging violation of Virginia employment rules. Augusta, correct me if I'm wrong, but I believe she lost, with the exception of she has a pending motion about whether or not she deserves 2 more weeks of severance pay. But though you told me that she's running for office, so you know, perhaps a silver lining. This is certainly an interesting campaign photo. So we didn't talk so much about First Amendment rights. We also didn't talk about things like defamation lawsuits. We didn't talk about things like if you want to file a scientific integrity complaint, just because we wanted to sort of hit some of what we've dealt with the most. If you have issues related to these topics, please come talk to us, or you can also visit our website. We have all sorts of educational materials on our site, csldf.org. Plus, we have printed materials in the back for people in person. We have a sort of guidebook to sorts of issues that scientists face. We have one specifically on activism, and we have a general brochure on our organization. On our website, we have more details on things like open records laws. We have a guide to writing open letters. As I discussed, there's a number of things that you can do to help protect yourself. And I think, you know, we are here if you have issues. We're here to talk generally about questions, but also if you find yourself under fire, please come find us or find a different legal group. But we are free, so it might not hurt to start with us. One thing that is really important to keep in mind is that your institutional counsel represents the institution, and that may align with your interests or it may not. And a big problem that we've had with scientists is they start talking to their general counsel, and the general counsel ultimately, it sounds terrible to say, but may not care what happens to you. The general counsel is out to protect the institution, whether that be the agency or the university or the company, and you can be collateral in that. So some general counselors are quite nice and will try to help you to the extent they can. Some are perhaps less invested, but regardless, like, they literally only represent the institution, not you. If you're dealing with any sort of, you know, retaliation, suppression, censorship, et cetera, it's a little hard to put that sort of advice on a bullet point in a slide because it is so situational dependent and depends where you work. So there's definitely the sort of situation to contact us or another group. But most places, especially the federal government, have multiple channels available to you with different political implications for using all of them. There are different trade-offs to be made if you're making an anonymous complaint versus a named complaint. There's balances to be made versus about being a public whistleblower versus keeping it internal. It's very obviously complicated set of decisions. So if you find yourself in a situation where you are evaluating that, I highly recommend you go and talk to a lawyer. We have some materials on public whistleblowing. The general advice is, to the extent that you can keep such things anonymous, it is probably a little safer. We partnered with UCS and some other groups. There's a guide out there. It's available on our website, and I believe on UCS and other groups too, called Making a Note to the Record. And it's about how to document such things so that if you ever do want to make such things public, whether through your own name or, you know, perhaps using some of these open records laws in a positive sense, that can be done more easily. Yes, yes. So for example, one of the things that we discuss in that guide is, let's say you're a federal agency employee and you're taking notes about some work drama. If you are keeping them as personal notes, then they are your property. If you are doing it on your work computer in your work time, they are probably agency notes and they don't belong to you. And that can be a good or bad thing depending on what you're trying to achieve. So there's more detail in there. And again, this is a sort of situation that is nuanced enough that I really recommend you talk to a lawyer if you're finding yourself on that path. If you're externally targeted, we have dealt with a number of scientists who have things like they are threatened with defamation suits. They actually face defamation suits. They get death threats. We once had to help someone serve a restraining order on someone. I mean, it can get really ugly, and there's a whole range of issues that researchers can face. But by and large, sometimes the delete key is actually your best friend, or at least the archive key. You know, if someone's sending you nasty grams, it may not be in your best interest to endlessly debate them. And, you know, archiving it, maybe deleting, not necessarily the best. You do actually want some sort of record, but putting it aside so that you're not thinking about that can actually be really helpful. But, you know, if you get a nasty letter and that person is from a congressperson, that needs attention. Same with subpoenas. We have helped researchers who were kind of brought into large, like multi-corporate litigation, and they get subpoenaed because their research touches upon something that the corporations are fighting about. That is really not something to mess around with. Open records requests, which we talked about, or anything, you know, threatening bodily harm or getting really harassing, that is that something worth talking about with a lawyer or law enforcement. These are the sorts of things actually in which your institution and your interests are aligned more often than some of the other cases. So it may be worth at least alerting your institutional counsel. But in any case, please contact a lawyer. And in summation, we are here. We are free. If we can't help you, we usually try to connect you with other groups. For example, UCS is not a legal group, but they do a lot of really great things on advocacy side. So we have referred people over to them when that makes sense. Or if you're having an employment law issue and we can't necessarily speak to that, you know, there are employment lawyers we work with. So we can certainly be a first stop of contact, even if we can't necessarily see it all the way to the end. As I mentioned, we have these resources. The advocacy and handbook we put in the back. The Make a Note to a Record is available on many organizations' websites, including ours, also our guide to writing open letters. And if you're interested in signing up for our mailing list, we have more materials coming out soon, including a more formal version of this anti-lobbying discussion that we talked about, laying out more of the details about what it means to be a federal grantee versus a federal employee, and how that affects your ability to interact with the legislative process.
And the sign up for the mailing list is also in the
Yes, thank you. So I think our last slide is actually just a contact page. Again, if you have any questions, please contact us. We are here. We keep everything confidential. It is really important to us to be able to protect researchers. So do not worry that we're going to be shouting your sensitive information to the press. And again, as I said, even if we can't help you, we should be able to refer you to the right resources for your situation. Thank you.
And I'll make, unless you indicate otherwise, I'm gonna just